Next case is Summit County Children's Services versus Ohio Civil Rights Commission et al. Each party will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. If you do plan to reserve rebuttal time, please let me know as I'll be keeping track of the time. Also, my understanding is the bailiff explained to the appellees or two appellees that you still only get 15 minutes and that you knew this in advance and have decided how to split your time.
Yes, Your Honor.
Thank you. The arguments are being recorded. When you present your argument, please introduce yourself, keep your voice up, and remain behind the podium. You should not use the name of children, minors, or victims in your arguments. You can refer to them by initials or terms like the child. We've read your briefs and are prepared to proceed when you are.
Thank you, Your Honor. Daniel Raderi on behalf of Appellant Summit County Children's Services. This case presents the straightforward but fundamental question of who is responsible for amending the Ohio Revised Code, the General Assembly sitting in Columbus or Congress and federal agencies sitting in Washington, D.C. In this case, the trial court abused its discretion and erred by holding that amendments made by Congress to the Federal Americans with Disabilities Act in 2008 govern Ohio court's interpretation of the Ohio Civil Rights Act when it comes to determining who has and does not have a substantially limiting impairment for purposes of determining whether a plaintiff or claimant is disabled. Even if this court were to disagree with us on the first issue raised in this appeal, the trial court also abused its discretion by holding that Deborah Webb, the complainant appellee in this case, was constructively discharged by Summit County Children's Services when she chose to retire while still on FMLA job-protected leave instead of applying for the accommodation of additional leave, which she requested and Summit County Children's Services undisputedly offered. And finally, if this court were to affirm the trial court's judgment on the merits, we believe the case should nonetheless be remanded for redetermination of Ms. Webb's back pay award on the grounds that the trial court misapplied the law and failed to discount the $1,442 monthly pension earnings Ms. Webb has been receiving during the back pay period. I'll begin with the first issue raised by this appeal, which is a question of statutory interpretation. Although we're here under an abuse of discretion standard of review, this court's precedents make clear that no court has the discretion to misapply the law or apply an erroneous legal standard. In this case, the trial court did just that by applying federal law codified by Congress in 2008 in connection with the amendment of a federal statute to the Ohio Civil Rights Act, which has never been amended by the General Assembly to follow the 2008 amendments made to the ADA by Congress.
What kind of change was made?
What kind of change was made to the ADA? Mm-hmm. Yes, so in 2008, Your Honor, the Federal Americans with Disabilities Act Amendments Act, which we'll just refer to as the ADAAA, said that a substantially limiting impairment need not significantly restrict an individual's functioning. And that's codified in 29 CFR section 1630.2J1.
Was that an amendment that changed substantive law there, or was it a clarifying amendment?
The amendment changed the rules of construction applicable to the statute. And here's where the conflict comes in. Under Ohio law, specifically Revised Code section 1.42, undefined terms in a statute are interpreted according to rules of grammar and common usage. And that's what both Ohio courts and federal courts were doing with respect to the phrase substantially limits before 2008.
So the Ohio courts were actually following what the federal law was doing then, prior to the change?
Correct, because the interpretive standards were the same. But that all changed in 2008.
But afterwards, Ohio did not do anything to change the statute.
Correct. Ohio did nothing. And in fact, the General Assembly has, since 2008, amended the Ohio Civil Rights Act to change it in other ways, most notably in 2021 with the Ohio Employment Law Uniformity Act. But they never incorporated these 2008 ADA amendments or anything like them.
But wouldn't it matter if that was actually a change on the federal level, or whether it was just a clarification? Because if it was just a clarification, maybe they wouldn't They could have said, we depart from, or if it's a change, we depart from this.
We believe it is a change because it changes the substantive rules of construction applicable to the Act. And in fact, the Anderson case out of the 8th District, which the Commission relies rather heavily on, held in paragraph 55 of that opinion that, quote, the current definition of substantially limits is much more lenient than the previous ADA standard. So even those Ohio courts which have held that we should follow the federal amendments say that there is a substantive change. It's not simply a correction or a new interpretation. It's changing the rules of construction applicable to the statute. And we think that that's contrary to what's codified in Ohio law. Again, Revised Code 1.42 tells courts how to define undefined terms. And that's what both Ohio courts and federal courts have been doing consistently with respect to substantially limits before 2008. Now there is a divergence in how federal courts interpret that term. Under the ADAAA, a substantially limiting impairment need not significantly restrict an individual. That's contrary to the rules of grammar and common usage because substantial and significant are in fact synonyms. But under the federal statute, they aren't.
Is it your argument that under the one definition, your position is is superior to the other position, or does the appellant or the appellee qualify under both standards?
They do not. They do not. And there's 3 factors that Ohio courts have traditionally considered when deciding whether an individual suffers from a substantially limiting impairment. 1, we look to the nature and extent of the impairment. 2, the duration or expected duration of the impairment. And 3, whether the impairment is long-term or permanent. I'll briefly address each of those 3 criteria to hopefully help explain our position on why, under the prior version of the law, Ms. Webb was not disabled. First of all, we're talking about essentially 1 month of impairment at the time the accommodation of sedentary work only was denied in early July of 2020. At that time, Ms. Webb was under doctor's orders to have a sedentary only accommodation from her anticipated return to work date at that time of July 2nd, 2020 until August 15th of 2020. And I want to point out that Ms. Webb was still on FMLA job protected leave through July 12th. So had she remained on FMLA through July 12th, as she was legally entitled to do, she'd be looking at a restriction of sedentary work only from July 12th to August 15th, approximately 1 month.
But was that certain that it would be August 15th?
That's what we know based on the medical records that were introduced into evidence by the Commission. And we asked Ms. Webb at trial whether she's aware of any further restrictions that were imposed upon her after August 15th, and she said there were none. And I know the Commission's pointed out that, well, there would be no need for further restrictions because she wasn't working anymore. Well, according to Ms. Webb, she was looking for work. So her doctor would presumably be telling her after August 15th whether she's capable of performing the functions that she wanted to perform, which at that time included teaching, which is not a sedentary only occupation. So the medical records only show that she had a restriction through August 15th. And the language in Dr. Bennett's June 25th, 2020 record for Ms. Webb's in-person visit to his office, which is page 500 of the OCRC record in this case, was emphatic. It said she is allowed to do sedentary work only until August 15th, 2020. Thereafter, she would have to do her regular duties. This was not simply saying sedentary work through August 15th, then we'll reevaluate. It was giving her a hard stop as to when this restriction
Didn't she
terminated.
get multiple dates here of when she was supposed to have the hard stop, but it kept getting extended?
Leading up to that June 25th, 2020 doctor's note. After that, there are no continuances or reevaluations that would cause us to doubt the certainty of the August 15th return to work date with no restriction. And that goes to the first element of whether someone is disabled, the duration of the impairment. But the second, well, the nature and severity, and I'll touch on that a little more. Ms. Webb, at the time she presented to Dr. Bennett on June 25th, was ambulating without any protective device, said she was without pain over the surgical areas of her right foot, and her only real restriction at the time was she was wearing soft shoes instead of hard shoes, Otherwise, she was able to walk, and Dr. Bennett's notes make that clear. Next, turning to whether this was a long-term or permanent impairment, which the pre-2008 case law requires in order to have a disability, Ms. Webb's counsel has conceded that this was, quote, a temporary disability, and that's at page 149 of the Ohio Civil Rights Commission record filed in this case. So we're confronted now with undisputed facts which show this was a short, temporary impairment which would not permanently affect Ms. Webb's ability to function, and that is in direct contravention of the standards that the Ohio Supreme Court set forth before 2008, and we maintain still govern the analysis in this case. To accept the Commission's contrary proposition, I believe, would be to hold that Congress, by implication, amended Ohio law when it amended federal law, and that's just not consistent with our federalist system of government. But I want to move on, unless the court has further questions about the statutory issue, to our second issue on appeal, which is whether the trial court abused its discretion in finding that Summit County Children's Services constructively discharged Ms. Webb. The standard for proving a constructive discharge is a high one. And in the context of disability discrimination, it requires a showing that multiple requests for accommodation were made, that they were denied, and that no reasonable alternative was offered. Importantly, in this...
But isn't that what the facts in fact show? That she wanted to work and she requested accommodation while everyone else was getting accommodation for COVID?
No, Your Honor, and I point to...
And her only options were to leave, take more leave, try to take more leave, or quit?
I agree with you on the second half of your questions, that her options were to take more leave or not just simply to quit, but to have the sedentary only accommodation,
Counsel,
which admittedly...
Just want, not to interrupt, but I would just say, was it to just take leave or unpaid leave without benefits? What was it?
Sure, it was leave without pay. And Ms. Webb, in her July 8th, 2020 resignation email, which is at page 610 of the administrative record, stated, and I quote, "As a result of being off on medical leave, my doctor recommended extended leave or return with light duty, which you will not consider, and that clearly is another example of being treated unfairly." She goes on to say that because Summit County did not give her either of those two accommodations, she's resigning and retiring. The problem is the very email to which she was responding on July 8th, 2020, which was a July 1st, 2020 email from Human Resources Supervisor Donna Testa, said, "Deb, here is the leave without pay request form, which you can use to apply for additional leave." So we're at this juncture now where Summit County is offering Ms. Webb additional leave. And then is the reason for her retirement and resignation, she's saying, "You would not offer me additional leave."
But there's no dispute that they weren't engaging in an accommodational type. Yeah, you're saying there's no disability, so therefore there should be no accommodation talk, but there's no dispute that there was never any negotiation about an accommodation or working without having to walk.
Yeah, I would disagree to an extent, Your Honor. I think that Summit County Children's Services said we cannot accommodate the sedentary only restriction because that prevents you from performing the essential functions of your position. However, we will offer you this additional leave, which in our view is in furtherance of that requirement to engage in the interactive process. And at that point, the burden would have been on Ms. Webb to say, no, that is not a reasonable accommodation for this, that, or another reason. And at that point, she could have said, it's not reasonable because I have to work. I don't have the financial stability to be on continued leave. She didn't do that. She just turned around and resigned and quit.
You have less than 2 minutes left. Do you want to reserve that?
I will, Your Honor. I'd like to reserve the final 2 minutes for rebuttal if anyone has any further questions at this time. Thank you.
May it please the court. My name is David Oppenheimer. I represent the Ohio Civil Rights Commission in this matter. I will be using most of the available time, and Ms. Webb's counsel will speak for the last couple of minutes. Your Honor, the lower court opinion does need to be upheld unless she abused her discretion finding there was reliable, probative, and substantial evidence in the record and conflicting evidence, such as opposing counsel has tried to cite to, does not meet that standard, does not allow for a reversal. Now, I want to follow up on something that Judge Sutton talked about under the ADAAA, and that's what change was made. And the fact is that no change was made to the actual definition of disability. And both, and in looking at whether Ohio courts should follow federal law and guidance in this area, you look first to what is the language of the two statutes. And both the federal law under the ADAAA and RC 4112.01813 state that a disability is, quote, a physical or mental impairment that substantially limits one or more major life activities. Identical language, identical results. What opposing counsel is ignoring about the ADAAA on this particular issue, it wasn't about saying Congress, the prior Congress, was wrong in the law it passed. It was saying the courts have misinterpreted that law. And as the First, the Sixth, the Eighth Ohio District Courts of Appeals have found, the Federal Northern District, Southern District, and Court of Claims have found, because of that, then Ohio should follow those same standards, and most importantly, not continue to make the same mistake that the judiciary had been making before then. So for that reason, the overwhelming body of case law has correctly determined that Ohio law should continue to be in line with federal law. Now, as you heard, in terms of that's the legal issue, the factual issue, opposing counsel noted that under the prior standards, Ms. Webb would not be disabled. That's the argument. They don't dispute, certainly in their brief and just now from the standards that were argued, that under the proper standards that should have been applied all along, she is disabled. So let's talk about some of the misstatements of fact that counsel just presented in the record of this case. Now, first of all, counsel tries to claim that Ms. Webb was impaired for a single month from June to July before she asked for accommodation. That's false. The impairment that she had was a bunion that was growing out of the side of her foot, which was curling or hammering one of her toes. That started in 2017, not 2020, 2017. And that impairment was only getting worse. It was not going to fix itself. It was not going to go away. That's what the surgery was for in February of 2020. Now, in February of 2020, following the surgery, which was necessary for her to be able to walk, she was getting to a point where she was unable to walk, which helps explain why she was working in the most sedentary job at Children's Services in the medical unit. At that point, she was unable to walk at all, unable to cook, clean, drive, so she was substantially limited in the major life activities of walking and caring for herself. Now, there was marginal improvement over the months. Initially, her doctor thought she'll be able to return fully in April. Turned out to not be true. She'll be able to return fully in mid-June. Turned out to not be true. By mid-June, while she had some improvement, her testimony and the medical records and the notes verify that she, in fact, was walking only minimally. She said about maybe 10, at the most 15 minutes, then I have to sit down, ice my foot, elevate it for extended periods, barely able to really walk around my apartment, again, not able to cook, clean, drive, take care of herself. That's why her doctor at that point said, as of July 2nd, she can engage in sedentary work. But at that stage, that's when Ms. Nash said, she's not disabled, so she gets no accommodation. She testified to that. I did not do anything to accommodate her at all. The supposed leave was not designed to be an accommodation. It was just the standard policy. In fact, as you noted, people were home due to COVID. Her coworker in the medical unit was home due to COVID. She was treated worse than her non-disabled colleagues were treated. So when she said, can I work from home? She was told no. In fact, you cannot return to work unless you have zero restrictions. So she provides a note. Estimated, and this is very important on the note of August, I have it right here. The estimated date where she might be able to return to work without restriction, with at least be able to physically come in, was August 15th, estimated only. Not certain, not locked in, estimated, circled right here on Commission Exhibit 16. When we've seen the time be pushed back from April, June, July, now into August, and her testimony was by mid-August, she was still limited and still could not have returned, and it was several more months. So look at what she was offered here, if you want to call it that. You can only return if you are able to walk, able to do every job duty, and have no restrictions. She didn't know when or if that would take place. It was possible it would never occur. She was told her position would be posted, which she understood to mean somebody else could snap it up. So even if she could return after July 15th or 13th when it would be posted, position might not be there for her. That is not a real option, Your Honor. So yes, she was disabled under either standard. And as I've been talking about in terms of constructive discharge, the test is whether or not the employer creates intolerable working conditions. Well, imagine being told you have to get up, walk into the office, walk around, be in here physically all day with that kind of restriction on her walking. And again, that's her testimony, that's her doctor's note. If she was, as opposing counsel said on June 15th, walking around just fine, fully healthy, everything was fine, you have to decide to reverse the credibility determination of the administrative law judge, ignore her doctor's notes, and that is contrary to the standard of review on the facts. So she's told you have to do that. It's like telling somebody who isn't disabled, you have to walk around with a 1-ton weight on your back. That's an intolerable working condition. And then being told you can only return if you can return without restrictions. She doesn't know if that's ever going to happen. That's not an accommodation. That is not realistic for her. So yes, she was absolutely constructively discharged. And a reasonable person facing that situation, where I can only return to work if I have no restrictions, if I do what is physically impossible, or I'm off work indefinitely and get no pay, no benefits, therefore no medical coverage, a reasonable person would have concluded it is necessary to resign. Now, I do want to talk about the issue of the retirement benefits and whether or not those should be subtracted from the back pay award. When looking at that again, like the definition of disability, we look at the statute. And RC 4112.05 G1A says that, quote, if the commission directs payment of back pay, it shall make allowance for interim earnings. It uses the word earnings. It could have used the word income. It could have said retirement income, pension benefits, but it decided on the word earnings. And as stated in the Jordan decision out of the 12th district, this is rooted in the principle of law that, quote, requires the claimant to use reasonable diligence to find other suitable employment. Other suitable employment. Meaning that you are working and you are getting money from active employment, not something like unemployment compensation where you get it because you used to work but aren't now, or workers' compensation where you were injured and can't work, only active employment. The Ohio Supreme Court told us in Ingram that this compensation provision is designed to provide a deterrent for discrimination to employers. Now, opposing counsel cites to a great deal of case law from the Age Discrimination Employment Act, or ADEA. And yet the ADEA is different because the compensation provision does not have a deterrent effect. And if you look at the cases cited on page 26 of the commission's brief, you'll see where that's discussed. If you look at the Cavan's decision, it talks about how retirement benefits should not be subtracted from a discrimination case similar to unemployment compensation that cites to Ingram. If you look at even the ADEA case law from Smith and Orzel, they list retirement benefits and interim income separately. So I want to touch, to conclude and give my co-counsel, or counsel for Ms. Webbs, a couple of minutes to speak. I want to touch on a couple of cases that they cite, appellant cites. Thurman v. Freight Systems, Inc. is the first one. Now, in Thurman v. Freight Systems, Inc., the issue was whether or not the collateral sources of unemployment compensation insurance and workers' compensation payments should be subtracted from a back pay award. And in analyzing that issue, the court said, well, how have we treated it in other cases? There are cases we've decided under Title VII, like Rosimus and NAFTA, in which we did not subtract such collateral sources. And then we have Holly v. Dresser, which was a case under the ADEA, where we did subtract the collateral source of retirement benefits. And they said, well, that's different because ADEA doesn't have that deterrent element in its compensation portion. Therefore, we're going to go in Title VII cases where you do have that deterrent element, and we are not going to subtract out these collateral sources. And finally, I want to talk about the McKinnon v. Nashville Banner Publishing Company case that they cite to. In that case, the court said that the ADEA is something of a hybrid statute, where the substantive portion has a deterrent element, but the compensation provision does not. Of course, we're talking here about the compensation provision if there's a violation found. And specifically, the court said, quote, the object of compensation is to restore the employee to the position he or she would have been in absent the discrimination. It says nothing about deterrence. So neither of those cases support appellant's argument. And in fact, I would say Thurman, by analogizing pension benefits to unemployment compensation income, undermines their position. Therefore, Your Honors, if there are no questions, I would simply conclude that the Children's Services cannot show that the lower court abused her discretion when she upheld the Commission's determination. And I would leave a couple of minutes for counsel for Ms. Parker.
Please support. My name is Ed Gilbert, and I represent Ms. Webb, and I'm here in support of Ms. Webb and also in support of the state of Ohio. In regards to this matter, I realize we're just about out of time. My remarks are going to be limited to the retirement issue, and I just ask you to consider this from the standpoint of reality. That is, you have a person here that ends up being told, look, you get no income, got no medical benefits, goodbye. And that's basically where she was. What is she to do? How is she to pay her bills? She's got a bad foot, and she knows she needs medical. What is she to do? She is to set up a situation where she will be able to take care of her bills, be able to get some medical. The only way to do that is retirement. And in my 45 years of practice in this field, interim earnings have never been interpreted to be retirement. I challenge the defendants to provide evidence otherwise. Our position is that certainly Mrs. Webb was in fact discriminated against. If you look at the defendant's position in this case, their position is Ohio citizens, quite frankly, never are disabled. The only way they get disabled is if they're dead. And our position is that clearly the citizens of this country, the citizens of this state have made it very clear that disabled people are human beings. Disabled people are entitled to work, and they can work and be constructive if they're provided reasonable accommodations. That's all we want, reasonable accommodations to do a job. Thank you very much.
We'll have about a minute and 45 seconds for rebuttal.
Thank you, Your Honor. First of all, I'd like to respond to Mr. Gilbert's point where he said that he would challenge us to point to any authority treating pension benefits as interim earnings. We cited to several federal cases in our brief, specifically the Sixth Circuit's cases in Hawley and Thurman. Mr. Oppenheimer mentioned both of those cases and tried to distinguish them on the grounds that those cases also addressed how unemployment compensation and workers' compensation benefits should be treated. Thurman is instructive because it distinguishes both of those from pension benefits. And it says that unemployment compensation and workers' compensation benefits are paid to carry out the social functions of the state. That is not what we're talking about here. That's what separates purely collateral, gratuitous benefits like unemployment compensation and workers' compensation insurance from employer-funded pension obligations, which are not paid to carry out the social obligations of the state and are not collateral sources under the long line of federal case law we've cited, and which the Ohio Supreme Court relied on in Ingram when it held that workers' compensation and unemployment compensation were not collateral benefits. So our point is that if we're going to look to federal law on this issue, then let's accept all of it and say that yes, unemployment compensation, workers' compensation, those are treated as collateral benefits, pension benefits are not. And as the trial court noted, this is an issue of first impression for Ohio state courts.
Does it matter that they are past earnings, maybe?
Yes, I think it does, and that's why they are earnings, because this court in 1978 in the Lully case said that pension benefits are deferred compensation, earnings paid out after retirement. So they certainly are earnings, even though they were.
But they're not being earned during that interim period.
No, Ms. Webb was not, earning $15 an hour during her back pay period and being issued a paycheck every 2 weeks. She was being paid the earnings that she had accumulated in her pension over the 20 years of her employment with Summit County Children's Services. And one final point before I run out of.
You're out of time.
I am. I
So
saw
if you
50
could-
seconds.
Stop it.
Okay.
If
All right.
you have about 15 seconds to wrap up.
Okay, my final point will be this. It's been argued here today that the courts were mistaken in their prior interpretation of substantial limits and that Congress corrected that mistake. Our point is simple. When it comes to an Ohio statute, the Ohio General Assembly is the only body that can correct Ohio court's interpretation of that law. Congress has no authority to do so. We therefore ask that this court reverse the trial court's judgment and hold that it was an abuse of discretion for the trial court to apply an incorrect legal standard. Thank you.
The court will take this matter under advisement and issue a ruling in due course. The clerk of courts will mail you a copy of the decision on the day it's released, and also our opinions are posted on the Ohio Supreme Court website. Thank you both for your presentation.
Thank you.